Yes, Mr. Ford. Number 5.
Number 5, arbitrary and unfair results, my lady. I won't say more about that. You've got our skeleton at 73. It's a matter of chance. Number 6, potentially can act as a serious impediment to the common law right of access to justice. So we rely, if necessary, on the principle of legality as expressed in unison and ex parte sims, which chimes with the purpose of construction. The court will recall how in Stringer, Lord Roger spoke of the need to issue repeat claims, which meant that claimants were incurring unnecessary expense. That needs to be seen in the context of wages claims, which are often for very small sums of money, particularly given they'll have to be restricted to underpayment in the last 3 months, and where the law is complicated. This case perhaps serving as a testament to that. So there's an obvious potential for interference with the common law right of access to justice that the gain may end up not being worth the candle. And I've referred you to, of course, Lord Reed in Unison at 96, where he talks about where it can be futile or economically irrational to issue claims, because lawyers aren't going to do this for nothing. So we say you should interpret the legislation in a way that avoids interference with the common law right by interpreting series as meaning series, at the risk of stating a tautology. I should say, finally, I said 6. There's always an extra one, isn't there? We're not aware, 7th, that Mr. Justice Langstaff's approach has ever been followed in relation to any other statute with a parallel limitation provision. I've never heard it suggested, for example, that the Section 123 of the Equality Act on continuing acts should be broken if there's a gap of more than 3 months. And we've seen the cases on whistleblowing where that hasn't been affected. There's also a series in relation to trade union discrimination, I think in Section 146, and again, never heard of that being broken. So that brings me on to the final point, which is whether or not a Regulation 14 payment is similar in kind to Regulation 13/16 underpayments during employment. And we say, to echo the Northern Ireland Court of Appeal in Agnew, they are linked by the common fault or vice that holiday pay was not correctly paid. They have the same source, Regulation 13 or 13A leave, Article 7, Article 31. They're based on the same leave entitlement. They have the same rules on calculating pay, a week's pay and or normal remuneration, and they have the same remedy provision in Regulation 31B. They also meet the same purpose, and if I could, just the one reference I wanted to show after lunch is Advocate General Trosteniak in Stringer, tab 26, page 388. Where she refers firstly to the purpose of pay during leave. The requirement to make that payment for leave ensures the worker is financially capable of actually taking his annual leave. Refers to an academic article and says the allowance in lieu has no other purpose. The allowance in lieu is intended in principle to enable a worker, even following termination, to take a period of pay rest before embarking on a new employment relationship. So they both meet the same purpose in EU terms. And for the court's note, you see that echoed in paragraph 61 of the court's judgment itself. That's at EU level. They also are the same kind in relation to the domestic analysis. and that's confirmed by Lord Roger in Stringer in the House of Lords at 25, paragraph 25, that's tab 25, page 346. I won't go to it now, where he said, as the court will recall, a Regulation 14 payment fell within the meaning of wages because, in common with a Regulation 16 payment, it was part of the consideration for services performed. So we say both domestic law and EU law chime together. These payments are for the same purpose and of the same kind. In their skeleton, the respondents say that this matter should go back to the ET for it to do a factual assessment of whether the matters are of the same kind, if we're right. That's paragraph 69 at page 52 DD. Where they say at the end, even if we're right on the whether the Reg 14 is the same kind as a Reg 16 payment, alternatively the question whether any Regulation 14 claim form part of a series would require a factual assessment. Well, we say no factual assessment is needed. In light of the authorities I've taken you to and the common sources of both payments, there's only one answer possible, that every time Mr. Smith went on holiday he wasn't paid, and the same common vice or common fault provides the sufficient connection with any Reg 14 payment which was due to him on termination. So we say the Court of Appeal should allow the appeal on this point, of course, but there's no need to remit on this specific question, although, of course, you will need to remit on other questions. Unless there's anything...
Sorry, I missed the paragraph. 52DD, where does it say you should remit?
Forgive me, my lady, it's right at the... I think it's right at the bottom of the page, where it says... Alternatively,
would require a factual assessment.
It will require a factual assessment.
Yeah.
Well, we say that's
69.
it doesn't need a factual assessment. It's clear they're of the same kind. Was there anything else, Madam?
Thank you. Anything?
Thank you.
No, thank you very much indeed, Mr. Yes, Mr. Glynn.
No, please, your ladyship. My part of this appeal poses 3 questions. Each of those 3 questions only apply to the 4 weeks of Euro leave under Article 7. Each of the 3 questions is presaged by the words, where an employer refuses to remunerate annual leave. Where an employer refuses to remunerate annual leave. Question 1, which is ground A. Where an employer refuses to remunerate annual leave, is the right to paid annual leave indivisible, so that taken unpaid leave is not the exercise of the right? Question 2, which is an elision, mostly ground A, but a small elision of ground B as well. Where an employer refuses to remunerate annual leave, is a worker denied an effective remedy? Where he has to take unpaid leave, in order to bring a claim for paid annual leave, having regard also to all the other factors in England and Wales. So, is a worker denied an effective remedy where he has to take unpaid leave in order to bring a claim for paid annual leave, having regard also to all the other factors in bringing a claim in England and Wales? Those are the 2 gateway questions to question 3. Where an employer refuses to remunerate paid annual leave, if the worker has not been given the opportunity to exercise his paid annual leave, either through no pay or an ineffective remedy, Does the leave carry over and accumulate until the termination of employment? So question 3 is, where an employer refuses to remunerate paid annual leave, if the worker has not been given the opportunity to exercise his paid annual leave, either through no pay or an ineffective remedy, does the leave carry over and accumulate until the termination of employment? Our first submission is that pay and leave are indivisible. They are a single right of paid annual leave. The exercise of unpaid time away from work is not the exercise of paid annual leave. Our second submission is whether or not paid annual leave is a single or a divisible right, the system of enforcement for paid annual leave rights in Great Britain, and I realise this court is only seized with England and Wales, but it's the law of Great Britain because deduction of wages in Northern Ireland is controlled under Agnew. It's not controlled in Great Britain except under Bare Scotland. Does the system for enforcement, and we say the system for enforcement in Great Britain breaches Article 7 of the directive, the Working Time Directive, Articles 31 and 47 of the Charter, and Article 47 obviously the right to an effective remedy, and the principle of effectiveness, if and so far that lives or breathes independently of Article 47. And then we say respectfully, simply applying the principles of the Court of Justice, we say that this court should be compelled to find that the paid annual leave rights carry over until the termination of employment. Before I start my submission 1, can I address what I call perhaps a canard of the respondent's case? And that is, they ask the question, is Mr. Glynn submitting that this should apply to underpaid leave? Pay of leave which is underpaid by a few pounds or many pounds? And my emphatic answer is no. The principles I will take you to in King apply to where an employer refuses to remunerate the leave because entitlement to the right to annual leave is in dispute. And that's the operative answer, operative part of King, and I'll take you to that. The only claims...
The employer refuses to remunerate because the right is in dispute.
Yes, to, if I can... They preclude the worker having to take his leave first before establishing whether he has... Sorry, I beg your pardon. Yes, because the right is in dispute. And in the words of King, in the case of a dispute between a worker and his employer as to whether the worker is entitled to paid annual leave under the first of those articles, they preclude the worker having to take his leave first before establishing whether he has the right to be paid in respect of that leave. And that's the operative part which we rely on. And it's only claims that are wholly unpaid that can carry over under the principles which I submit.
Only claims that are wholly unpaid.
Wholly unpaid. That's the case of Mr. Smith. Is every time he took time away from work, he was paid nothing because it was in dispute whether he was a worker or not. Like Mr. King, milady, when Mr. King came before you, he had 2 claims, holiday pay 2 claim, which was dealt with before it came before the Employment Appeals Tribunal because the law and series of deductions was different. So he could mount his holiday pay 2 claim and find vindication of it. Then when it became before Lady Justice Simler, Bare Scotland had changed the law, so there was no appeal, however.
But you could have it, I mean, that's just the facts of King. You could have a situation like BA and Williams or a commission case where there was a dispute about pay, not worker status, so that the employer remunerated partially. But you're saying that this argument doesn't cover that sort of a case.
Milady, I'm not precluding it from being argued in the future. What I'm saying on Mr. Smith's case is that it's only a case of wholly unpaid leave, and it doesn't engage the court, a partially paid right. So I don't answer that question because on the facts it's not required of the court in this case.
But you're not saying as a matter of principle that it Well, you're just not going that.
I'm not.
Okay.
I'm absolutely. What the respondents have said.
You're ducking that.
You're
You're
Yes.
leaving it alone.
Yes, because
You don't need to go there.
precisely.
Trojan horse.
Can I start firstly at King in the EAT, and I do so because my own friend Mr. Ford has already taken you to Article 7. But can I take you to then to Divider 34, page 619. Divider 34, page 619. My own friend Mr. Ford has also taken you to the provisions of the Working Time Regulations, and I won't do so again. But what my Lady Justice Simler held, and held correctly, we say at paragraph 15, is although Article 7.1 provides a composite entitlement to paid annual leave, and that's the word we use again and again in the skeleton, composite entitlement. It's the word my Lady Justice Simler uses because, as we'll see, the single right it's called. The Working Time Regulations provides for entitlement to annual leave in Regulation 13 and separately Regulation 16 for pay. So what you have under the Article 7 is you have this wrapped up principle, paid annual leave. And then entitlement to leave at Regulation 13 and pay for that leave at Regulation 16. And then the gateways that Mr. Ford took you to under 31A, either you refuse leave, and if you go under 31A, you enforce it under paragraph 3 and paragraph 4. But in a case such as this, only if payment has failed, and it's the past tense in Regulation 16, has failed to pay. And one can see that perhaps without, if one goes over the page to paragraph 27, and one can just see that here for the note, is that if one looks under 1AB, at the top of the right-hand column on 621, can you see has failed to pay him? And then if you look under paragraph 5, second line of paragraph 5, just a few lines down between the hole punches, has failed to pay a worker. Now that has the important consequence that any right, any effort of someone in Mr. Smith's shoes in order to sue for the right to pay has to take unpaid leave. He has to suffer the slings and arrows of a complete deduction, the certainty of a complete deduction of, let's say, a week's wages, for the prospect of the outrageous fortune of 1 week's wages. So he has a certain loss of a week's wages for a contingent chance to recover a week's wages. It's the only way that Regulation 16 and 31B can work. And that, in a way, is where the problem starts. That bifurcation of the rights and the entitlements under United Kingdom law. And what one sees is a failure, we say with respect, for United Kingdom law to see this as European jurists do, which is as a health and safety right. And once you understand it as a health and safety right, you would never ask, would you, an employer who is injured by a machine to come in and show that he didn't take care or he didn't fix the machine. You would always look for the employer to demonstrate that they did, for instance, everything that was reasonably practicable. And that's what you see in Kreuziger. You see a foundation of that is the burden is on the employer. Because Article 7, we've always seen perhaps as English jurists as a right to leave and pay. But actually it's a health and safety right. And because of that, you will see, I make good my submission, that in fact it is a single right to paid annual leave. And can I take you please to the cases and start with Robinson Steele at Divider 22. Robinson Steele at Divider 22. I beg your pardon, my ladies, I don't know where your folder divides.
40 is the last one into the second bundle of authorities.
40.
King is the last
Last
one
one,
in,
thank you, I'm grateful.
authorities one.
So if one starts at 42, sorry, I beg your pardon, at 22.
Yes, Robinson.
Thank you. And if I can take you to page 296. My ladies, I'm sure the facts of this will be familiar to at least two of you. As Robinson Steele was a rolled up holiday pay case. What happened is the three groups of claimants either were paid a day rate when they were working, or they were paid an hourly rate, and the employer in each case said between 8% and 13% of your hourly rate is hypothecated for holiday pay. So when you take your time away from work, you won't get any pay, but we've paid you in advance because that's what we've done. And the Court of Justice considered that question at page 296, paragraph 53, is whether part payments staggered over the corresponding annual period of work and paid together with the remuneration for work done, rather than in the form of a payment in respect of a specific period during which the worker actually takes leave, is that practice precluded? And the Court of Justice held it was, but on these bases. Is firstly at paragraph 54, they accepted Article 7 doesn't say when pay must be made. But under paragraphs, I beg your pardon, paragraphs 55 and 56, it was up to the member state, conditions for entitlement, to set those conditions. But there are limits, and those limits are set under 57. In that regard, the member states must ensure that the detailed national implementing rules take account of the limits flowing from the directive itself. So it's up to the member states, but it would be circumscribed by the directive. And then at 58, you'll see something that becomes rather like a Greek chorus, as I show you in all the cases, is the directive treats entitlement to annual leave and to a payment on that account as being two aspects of a single right. The purpose of the requirement for payment for that leave is to put the worker during the leave in a position which is, as regards remuneration, comparable to periods of work. And they restate that in 59, and then they restate at 60 that the prohibition, that is, that you can't pay in lieu, is intended to ensure that a worker is normally entitled to actual rest with a view to ensuring effective protection of his health and safety. It's not just pay and holiday, it's important, and I think we'll all know that if we don't take holiday, it affects us. It's a health and safety right, and that's the prism which I'd like, in my submission, this court should start to analyse the right under Article 7.1, health and safety right, and that's why we see the burden put on employers. And then they go on, and at 61, a regime such as that referred to by the question at issue may lead to situations which, without the conditions laid down in Article 7.2, and the conditions in Article 7.2 is employment must be terminated, then you get a payment in lieu. Now, that principle is re-emphasised and expanded on, if one goes forward, please, to Divider 26. And my learned friends have referred to this case as Stringer, but in the EU it's known as Schultzhoff, but I understand as both my learned friends were in Stringer, then I must also refer to it as Stringer. But if we go to page 408, the court was considering the right to take paid annual leave during a period of sickness. And here the question for the court was, can one take annual leave during sickness, or is that precluded by Article 7? That was the simple question. And at the bottom of 408, paragraph 23, a worker must normally be entitled to actual rest with a view to ensuring effective protection of his health and safety, since it is only where the employment relationship is terminated that Article 7.2 of the directive permits an allowance. And then at paragraph 25, just below that, you have a statement of the purpose of the entitlement to paid annual leave. It's common ground, the purpose of the entitlement is to enable the worker to rest and to enjoy a period of relaxation and leisure. And the court goes on and they distinguish that against sick leave, which is obviously in order to recover from being ill. If one then turns forward, please, to page 413, that purpose, that is the purpose of the worker to rest and to enjoy a period of relaxation and leisure, is picked up in paragraph 60 on page 413. And you'll see, I'm not going to read it out, you'll see an exact analogue of what you've read already in Robinson Steele. So for the second time, the Court of Justice repeats that it's two aspects of a single right, and the purpose is to be in the same position as you're away from work. And we know the purpose is so the worker can enjoy rest and relaxation. Then go forward, please, to to divider 27, British Airways and Williams, again a case in which both my own friends were involved. It should be said, but it's not. It should be said that this wasn't a case under the Working Time Directive. It was actually a case under the Civil Aviation Working Time Directive, but for all intents and purposes, it was analysed precisely the same, and it is in the same terms. But can I take you, please, to Advocate General Tristagnac at page 427. Page 427. And halfway down 427, she analyses the principles established by case law in relation to the right to paid annual leave. And 4 lines from the bottom, she says, the purpose of the entitlement to paid annual leave is to enable the worker to rest and to enjoy a period of relaxation and leisure. And that's the health and safety right, again repeated. Over the page, paragraph 46, she repeats word for word what the court has already seen twice, the right to the single right. And then 5 lines down, she expresses the first important legal conclusion that can immediately be drawn from that statement is the following. Since the court takes the view that the two rights are to be regarded as being inseparable from each other, the right to payment of holiday pay must likewise not be derogated from when it comes to implementing European law at the level of the member states. So there you have her expression, her opinion, in precisely the same way as we've seen before, that this is one of the red lines the Working Time Directive draws. Not to give leave without pay. They're inseparable. And it must be pointed out that Article 7 is not one of the provisions from which the directive expressly permits derogation. Not taking you to it, but my ladies, that's Article 17 of the Working Time Directive. You cannot derogate from Article 7. You can derogate 3 to 6 and 8 to something or else, but you cannot derogate from Article 7. Since that provision must not be derogated from to the detriment of the worker either in law or in contract, the Danish government's view to the effect that the right under European law to the payment of holiday pay is mandatory in character must in principle be endorsed. It's mandatory. And taking you forwards, please, to the judgment of the court at page 447. Page 447, paragraph 20. I'm not going to read it, but you can see there yourself. You've effectively, and one sees like Court of Justice decisions, they're like barnacles on a ship sometimes, aren't they? They accrue the principles again and again. Paragraph 20, the principles restated, and then the single entitlement is restated in the last 4 lines of paragraph 26. The Working Time Directive treats entitlement to annual leave and to a payment on that account as being 2 aspects of a single right. So we've seen it in Robinson, Steele, Stringer, BA and Williams, and finally we're going to see it in Locke. And can I ask you please to turn to divider 32, page 598. 32, page 598. And here at paragraph 17 you see precisely what you've seen before. But just taking you quickly to the facts, and I can be short with Locke, I know, in front of this court, is Mr. Locke was paid £1,200 basic a month, approximately, and £1,900 a month in commission. And when he took his leave, he didn't earn his commission. But when he took his leave, that was not when he suffered the loss of earnings. Because he was paid in arrears, and his 2 weeks away, he continued to be paid exactly the same when he was away from work. He suffered a loss, not a complete loss, a partial loss, when he came back to work. And the submissions were made, and it's sidelined, the submissions were made that, well, that doesn't affect annual leave. And the court said no, on the principle of dissuasion. Of course, you'd go away and the fact you'd suffer loss. But again, each of these cases are not are underpayment cases. What we've seen in Locke and what you see in BA and Williams, as my Lady Justice Simler remarked, they're underpayment cases, but still the principles apply. Which takes us then to divider 40 and King. and particularly page 739. Firstly, I just want to take you to the question at paragraph 31. The question referred is whether, and it was a question posed under both Article 7 and Article 47. And you'll see that my submissions aren't watertight from each other. They probably inform each other, and there'll be some leaking across, certainly to save time as well. And the question is, must those two principles interpreted as meaning that in the case of a dispute between a worker and his employer as to whether the worker has the right to paid annual leave under the first of those articles, they preclude the worker having to take his leave before establishing whether he has the right to be paid in respect of that leave. Pausing there, that's Mr. Smith's case. In order to assert any right to leave, he had to first take his leave, and then, as my friends say, he should have pursued it under Regulation 16 and a Regulation 31B claim. So that question directly affects Mr. Smith's case. It's on all fours with it. At paragraph 32, my learned friend took you to no particularly important, but can I on the second line again stress no derogation? At paragraph 33, they refer to the charter right having the same effect as the treaties, and you've heard my learned friend's submissions about Choudhury. And then at paragraph 34, for the fifth time, this court has read what the court has said about the single right. Paragraph 35, I beg your pardon. Paragraph 34 is different but important, and that is the implementation or exercise of the right cannot be made subject to a precondition. Can I just pause there? I could keep it to the end of my submissions, but it's obvious, isn't it, that if you look at Regulation 31B, has failed to pay, the only way that a person who has not been paid or can take leave away from work but will not be paid by the employer, the only way that person can trigger a right is to take unpaid leave off. So just on that analysis itself, you have the precondition. But it goes more. At paragraph 35, you have again what you've read time and time again. But it's paragraph 36 to 40 which give the real meat to the bones of the principle at paragraph 35. 36, it follows from the foregoing, when taking his annual leave, the worker must be, and we've read that again, it's a restatement. Paragraph 37, the very purpose of the right to paid annual leave, worker rest and relax. We've read that. But then here at paragraph 38, the court addresses particularly the submission that my learned friends make. As the European Commission notes in its written observations, a worker faced with circumstances liable to give rise to uncertainty during the leave period as to the remuneration owed to him would not be able to fully benefit from that leave as a period of relaxation and leisure in accordance with Article 7. I say it means what it says. Now, if there's uncertainty, that is, you might get paid, you might not get paid, or in Mr. Smith's case, he never got paid, he does not benefit from the period of relaxation and leisure in accordance with Article 7. And where you have the single right, two aspects, you have the single right to paid annual leave, two aspects of that right, where paid leave must be regarded as inseparable, as Advocate General Tristignac said, and mandatory, as in her opinion she said, and then you chime that with 38, you're left, we say, with the obvious conclusion that failure to pay means that the health and safety right is not being discharged. The Article 7 right is not being discharged. And just stopping there, that's Mr. Smith's case. Mr. King's case wasn't actually he took leave. But it goes on, the Court of Justice goes on at 39 and addresses Mr. King's case. So just looking at 36 to 38, that's all about facts like Mr. Smith. But at 39, the Court says similarly, and they use the principle that learned friend submitted fully on the principle of liable to dissuade. The Court continues, just to note at paragraph 41, they note, and it's not in dispute between the parties here, that Article 7 must provide, there must be an effective remedy. And then at the top of page 741, And this is based, the Court of Justice bases its analysis on the judgment of Lady Justice Simler in EAT. And it says there are two possible claims at the top of page 741. Either the claim, obviously under Regulation 3131A, refusal by his employer to recognise his rights to a period of annual leave, or to argue that his employer has not paid him for all or part of that leave pursuant to Regulation 16. And then, as Lady Justice Simler found, and as I submit, that one's left with two possible claims. A claim for the breach of the right to annual leave, that's just entitlement to a period of leave under Regulation 13. But it doesn't seem to be the case that there was any failure to permit Mr. Smith to go away from work. Or two, on the basis of Regulation 16 of those regulations, could claim payment only for leave actually taken. And that's obvious, has failed to pay. At paragraph 44, however, in a situation in which the employer only grants unpaid leave to the worker, and that's why I'm restricting my submissions as I do, not only on the facts but also on the Court of Justice principles as it says, such an interpretation of the relevant national remedies would result in the worker not being able to rely before the courts on the right to take paid leave per se. And effectively, there's no way under Regulation 30 that a worker can go to the court and say, give me my leave. Effectively, a bit like Oliver, he has to wander off, take unpaid leave, and then hold his bowl up. And as the court finds to do so, he would be forced to take leave without pay in the first place, and then to bring an action to claim payment for it. Can I just stop there? That's not impossible. It's not impossible for someone to take leave and then bring it. We're not talking about impossibility. Impossibility comes in later. We're talking, and that's why we're talking about excessive difficulty or practically impossible. We're not talking about impossibility. It is always possible for someone to take unpaid leave and then bring a claim for it. And indeed, that was, Mr. Smith took leave. However, just on those facts, at paragraph 45, the Court of Justice arrives at a conclusion. Such a result is incompatible with Article 7 of the Directive for the reasons set out in paragraphs 36 to 40. And that's on the basis of having to take leave and then claim for it. Nothing else. This isn't King untaken, this is Smith taken, not paid. But of course the court goes on to deal then with Smith untaken. But before it does, can I ask you please to take out the IRLR's version of King we handed up this morning and turn please to the Advocate General's opinion. And particularly please to paragraph 90, paragraph 91. And again, you see the long-established case law, the referral at paragraph 91.
So this is, 91 of the Advocate General.
I beg your pardon. This is Advocate General Tanchev. And just setting out the single principle. But at 93, the Advocate General then gives an opinion. Second, obliging a worker to take unpaid leave before being able to establish whether he should be paid for it is also inconsistent. I've described at point 55, and point 55 is a mention of effectiveness. To supply remedies for enforcement of Article 7 that provide a real deterrent effect against breach by employees. Such a requirement renders the right to paid annual leave excessively difficult to enforce, given that there would seem to be nothing in the role of such provision in the procedure, its conduct, or any special features to justify such an impediment to exercise the right to paid annual leave. And so he goes on. But it's at paragraph 94 particularly, and again, I'm submitting both. I can see that I'm leaking into effectiveness, and I don't mean to. This is my single right point. But 94 makes my single right point for me, we say. Thirdly, any decoupling under United Kingdom law of the right to leave from the right to be paid for it may mean that the remedy provided for under United Kingdom law may be of inordinate complexity so as to give rise to breach of Article 47. 47. And we say, again and again, the right Article 7.1, the paid annual leave is a single right. So that's all based on Smith's, but just on Smith's fact. But just to go on, because what happened is the tribunal here distinguished King and said those principles don't apply to us because they only dealt with King untaken. At paragraph 46, the court says a fortiori, which Mr. Ford tells me means a supplementary reason or an extra reason, in the case of a worker in a situation such as Mr. King, is the national remedies are interpreted as indicating paragraph 43, it's impossible. So Mr. King is in the impossible situation. But as you've seen, the Advocate General has given the opinion that it's excessively difficult to take leave. And in fact, that's also the operative part of the Court of Justice. At paragraph 47, the Court of Justice decides, under both Article 7 and the principle to an effective remedy, must be interpreted as meaning that in the case of a dispute between a worker and his employer as to whether the worker is entitled to paid annual leave, such as with Mr. Smith, where the dispute went all the way to the Supreme Court, leave in accordance with Article 7 of the directive, they preclude the worker having to take his leave first before establishing whether he has the right to be paid in respect of that leave. I'm going to come back to effectiveness, but just looking at the single right. Why do they do that? Because of the single right. They do that because the right to pay and the right to leave is the right. And to divorce them, as Mr. Smith has had to do, is precluded. So we say it's simple that King goes far beyond untaken leave. It sets out the principles absolutely clearly as to having to take leave. And indeed, if one looks at paragraph 47, that is the operative part of the judgment, and it appears at paragraph 66, the answer to the questions. So that's why I say with respect, not only does the principle apply, but the ratio applies to Mr. Smith. And that single right simply been denied him. Mr. Smith, on each occasion, you've heard the denial of the denial. On each occasion, he was forced to take unpaid leave. Which moves me on, please, to Article 47 and the principle of effectiveness, as informed by Article 7. It's not in dispute that there needs to be an effective remedy. The test is not in dispute either. It's practically impossible or excessively difficult. I've given you the test of impact, the authority of impact. And that test involves, as we've set out in our skeleton at page 35, para 94, I'm not going to take you to it, whether procedural rules make it excessively difficult requires an analysis of the procedural rule in its factual and legal context, must be analysed by reference to the role of that provision and its progress and special features, and takes account of each case's own factual and legal factors. And I'm going to show you particular factors in Mr. Smith's case, which are important. Lord Reid in unison, which, if I may please take you briefly to divider 47, Lord Reid in unison set out at paragraph 106, page 965. Sorry, I beg your pardon, 964. Article 47 is as you can see, begins at 107, Article 47, and then over the page, second line down of the paragraph, restriction must retain a reasonable relationship of proportionality between the means employed and the legitimate aim sought to be achieved. So what the court has to do here, we say with respect, is what it's very used to doing, is a proportionality examination, looking at the aim, the legitimate aim, the importance of the principle, and the effect on that. And if one then turns over the page to page 116, one sees Lord Reid at the third line, when examining Article 47, it's not determined solely by affordability, but further down, and can I say, these aren't obviously fees, but can I just draw an analogy between fees and Mr. Smith? As I said, I hope not to be repeating the point, but every time Mr. Smith wants to bring a claim for his holiday pay, he has to take, under UK law, he has to lose the same amount. So proportionality also requires other factors to be considered, including the stage of the proceedings at which the fees must be paid. Mr. Smith has to lose the amount before he can even claim. He doesn't get a claim until he loses the amount. And whether the payment may result in the claim never being examined on its merits. Well, that's what my learned friends say. Unless Mr. Smith takes the time off and then makes a claim, he can never claim for any pay. They also include a factor which is of particular importance in the present case, namely whether the fees are proportionate amount to the sums claimed in the proceedings. And I'll show you futility and irrationality when I come to this, the factors. Ultimately, the question is whether the limitation of the right to an effective remedy resulting from the fees order respects the essence of that right and is a proportionate means of achieving the legitimate aim. So those are the tests, but before one examines the factors, can I again draw back to Article 7? It's a charter right for every worker. It's a health and safety right. Those factors weigh particularly importantly in the balance of proportionality, heavily if that right is going to be interfered with. You need time away from work because it's stressful. You need pay because unless you're paid during work, you can't enjoy and relax. And so the first reason we say that obviously the right is ineffective is because the Court of Justice has told us so. Article 47. Just simply by itself, having to take unpaid leave in order to trigger the right is a precondition of the right, makes it excessively difficult. The Court of Justice has said so. But we go further. So that's factor one. We go further. In fact, we're only getting started in the law in England and Wales as to why it's excessively difficult, because we have at the moment bare Scotland, subject to this court's decision. So you have the second factor, procedural complexity. Claims have to be issued every 3 months, frequently during the year and across every year. If Mr. Smith takes half a day of leave, he needs to issue for that tiny sum of money a claim. There's no legitimate aim for that procedural bar. None. It serves no sensible purpose whatsoever. And in fact, on the facts of Mr. Smith, between 2005 and August 2011, he would have had to issue 23 claims. Or my learned friends say, well, actually, don't worry, he'll only issue one claim and then make 22 amendments. Every time Mr. Smith took time away from work, he would be living under a ticking clock of having to issue an amendment within 3 months. And never missing that, because if he misses one day, if one of those 22 amendments is a day out of time, his series is cut. My learned friends refer to a 2014 presidential direction. It's a bit like what Pimlico Plumbers did to the original Employment Tribunal, which is put forward, as Lord Wilson said, an irrelevant contract because it affected employment after Mr. Smith's termination, and relied on the tribunal misconstruing that irrelevant contract. Of course, 2014 was some 3 years after Mr. Smith's termination. It's wholly irrelevant. So that's factor two. Factor three is the futility and irrationality. In order to bring a claim, Mr. Smith needs to sacrifice 1/12 of his pay every year. Not only is that a powerful disincentive, but he faces that real loss. And not is there just uncertainty as to the loss, but also, if one can please just turn briefly to, I hope you're still in unison, to page 946, paragraph 36. Page 946, paragraph 36. And Lord Reid relied on a 2013 payment of tribunal awards, which is relatively close in time, isn't it, to Mr. Smith's termination. and certainly close in time to when his claim came before the tribunal in 2012, as it was first determined. Only 53% of claimants who were successful before the ET were paid. Even after enforcement action, only 49% are paid in full, a further 16% being paid in part, 35% don't receive a penny, and then even when BIS changed the law in order to make enforcement stronger, in a 9-month period they only enforced 31 of the tens of hundreds of awards the Employment Tribunal made. So not only is he faced with the uncertainty of a contingent award, but then he's also faced with the uncertainty of enforcement. And there's the cost of pursuing the claims. Having to reissue 23 claims or amend them 22 times. Lawyers don't work for free, there's no legal aid, and the legal fees are bound to be in excess of what's at stake. And it's an unnecessary expense, as my own friend Mr. Ford showed to you when talking about series of deductions. Workers are often low paid, and some would have tiny claims, and we say this is on all, this is the paradigm example of a pointless, futile, irrational claim, as Lord Reed summarised at paragraph 96 of Unison, which I'm sure this court will be aware of. The fourth factor is a worker whose employer refuses to remunerate holiday is insecure. It rather proves itself by the statement. A worker whose employer refuses to remunerate his holiday, his paid holiday, is insecure because necessarily he is employed by someone attempting to avoid their obligations. We know that workers are vulnerable and they're reluctant to issue single claims. We know that because Kreuziger tells us that at divider 45, please. Divider 45, page 907, paragraph 48. The worker must be regarded, at paragraph 48, the worker must be regarded as the weaker party in the employment relationship. It's therefore necessary to prevent the employer from being in a position to impose upon him a restriction of his rights. On account of that position of weakness, such a worker may be dissuaded from explicitly claiming his rights vis-à-vis his employer, where in particular doing so may expose him to measures taken by the employer likely to affect the employment relationship in a manner detrimental to him. And one can only begin to imagine what the effect of not issuing one claim, but 23 different claims might have had an employment relationship. And indeed, if I can take you please to Advocate General's opinion in King at paragraph 3. If this is behind divider 40 perhaps, and it's paragraph 3 of the Advocate General. Mr. King is merely one of the Resolution Foundation found 1 in 20 workers in Great Britain who are denied the right to paid annual leave. And as Advocate General Tanchev expresses at paragraph 3, the problem to hand is of acute social importance given the increasing number of people across the European Union who work on flexible, casual and intermittent bases. These forms of employment are becoming ever more prevalent because of the provision of services via digital technologies in the age of the internet. And just stopping there, one can be aware of the Uber cases, of the other app-based cases, where workers have never been afforded a day of paid holiday until the Supreme Court determined otherwise. Who should bear the risk of non-compliance with the right to paid annual leave where there is no facility in the employment relationship for its exercise? The employer or the workers concerned? And in fact, what Advocate General Tanchev went on to do is set out the facility argument, a baton which Advocate General Bow and the Grand Chamber in Kreuziger and Shimizu took up with alacrity, and effectively made it, adopted his proposition of the facility. Is it compatible with the EU right to paid annual leave for member states' law to first oblige a worker to take leave before being able to ascertain if the leave will be paid? And in the circumstances of the main proceedings, what limit, if any, should be placed on what a worker like Mr. King might be able to recover through an allowance in lieu? So that's the fourth reason is the necessary insecurity. The fifth and final reason on effectiveness is the respondent's conduct materially caused the excessive difficulty. Mr. Smith had his case heard in what would be now considered quick time. His claim came before Employment Judge Corrigan in 8 months on the 17th of April 2012. Pimlico Plumbers appealed. It came before His Honour Judge Sirota on the 21st of November 2014. Pimlico Plumbers appealed. It came before this court on the 10th of February 2017. Pimlico Plumbers appealed. The appeal was then dismissed. On the 13th of June 2018, 7 years after the first hearing, 7 years after presentation of the claim. And looking at Pimlico's conduct, I'm just going to give you the references because the court's indicated that you've carefully considered it. Can I give you the references for His Honour Judge Sirota's judgment? And that's to be found at Divider 29, page 490, paragraph 43.
Sorry, just a moment.
I beg your pardon, lady. So I'm just giving references rather than...
Yes,
sorry,
understood.
I apologise. So it's Divider 29, page 490,
Yep.
para 43, what he describes as carefully choreographed. Page 522, paragraph 123. And here you have Pimlico Plumbers' best commercial interests. And what those best commercial, it's important to bear in mind, the respondent saw was its best commercial interests. And what that best commercial interest is made clear over page 523, to be able to avoid the obligations and protections made available to employers and workers under employment and equality law. It was a scheme for avoidance. And if one looks, if I can give you two references, please, to Lord Wilson's judgment in the Supreme Court, at page at Divider 39, page 725, paragraph 26, where he notes the irrelevant contract that I've told you about, the irrelevant contract Pimlico put in front of the tribunal that only was enforced after Mr. Smith left. The irrelevant contract in highly confusing terms, and now Pimlico complains about the judgment being confused about that, and that's at paragraph 26, page 725. And finally, paragraph 33 of page 727, where Pimlico's submissions stretched natural meaning beyond breaking point. And this was talking about the right to substitution, where the contract said you, your, you, and it was submitted, well, that doesn't mean the operative, it means someone else. Someone else can substitute. And Lord Wilson said, well, you're stretching language beyond breaking point. And then the final sentence of the judgment, where Lord Wilson says, effectively, words to the effect, if you'll forgive me for paraphrasing, I won't lengthen the judgment by addressing the paucity of that final complaint. What Pimlico Plumbers has done is it's benefited in its best commercial interests in trying to avoid employment law from two things. Firstly, just like Mr. King, and just like Mr. Smith, you've heard he never took his full leave. If you don't pay someone, if you refuse to pay someone, what that person nearly always does is to be dissuaded from taking it and give you more service. You make more money from them. But if, like Mr. King and or Mr. Smith, they also take unpaid leave, you have a second direct financial benefit. You pocket the money that should be theirs. And that was the Pimlico Plumbers way in which it traded its business, so that it was recently sold for over £100 million, one reads in the newspapers this year. So we say that the respondents are right. Mr. Smith could have brought a claim. I'm not saying it's impossible, but I am saying it's excessively difficult because of the 5 factors, including the binding determination, we say, of the court. And also, what do we know of the facts that would have led? How does my then friend Mr. Jeans put in his skeleton argument? Had Mr. Smith, on his first year, thought, oh, I think I should have the right to paid annual leave. I know, I'll put in a claim for the right to paid annual leave. I'll take a week off, but then I know it will be resolved quickly. Well, that's not a submission open to my learned friends, because it took them 9 years because of their unsuccessful appeal after appeal after appeal after appeal that delayed the claim 9 years. Even had, on the facts of this claim, Mr. Smith put a claim in on his first day of employment, he would have seen nothing until, he wouldn't have had a hearing till 9 years later in 2014. And that was, it's clear, even we say you don't have to go beyond paragraph 47 of King, on any case it was excessively difficult, and all the other factors. So either Mr. King takes leave off and waits years and years and years, or he takes no leave off. He works all the time and he brings a King claim. And what kind of impact is that going to have on someone who never takes a day's leave? This is the paradigm case of excessive difficulty. And we must remember why Article 7 exists. It exists, like Article 31 of the Charter, to give every worker the right, that health and safety right. And when you look at the fact he has to take leave, he has to take unpaid leave even to trigger the right, the procedural complexity, the futility and irrationality, the insecurity and the conduct of the respondent, you are left, I say, my ladies, with no doubt that this is an excessively difficult case. Now, can I take you then briefly, please, to the judgment of the tribunal, and I will identify where those errors are, but as you can see by my submissions, it's a full attack on the whole reasoning of the tribunal. And if you go, please, to page 153 of the core bundle, page 153. My own friend Mr. Ford took you to the 2 last sentences of paragraph 28. But just having gone through now the principles of King with the court, the claimant's claim is pleaded and on the facts can only be a claim for holiday pay 2, that's taken but not paid. The reasoning in the Court of Justice decision in King did not concern that kind of holiday pay. Yes, it did. That was the operative provision. And then paragraph 29, but it did so in the context of a set of facts in which Mr. King was deprived of a remedy because of this division. Further down after the italicised, the claimant is not in that situation. Having taken leave, he was entitled to bring a claim for payment in accordance with Regulation 16. He therefore was not deprived of an effective remedy. Well, they're wrong. Well, they're right to one extent. He wasn't deprived of a remedy. I've accepted that. He could have taken a remedy. What matters is whether under Article 47 it was an effective remedy. And just on the finding in King plus the other bases, he obviously was denied something. He was obviously given a remedy that was excessively difficult or practically impossible. And then I do not think it's open to me on the facts before me to say that division between pay and leave in the Working Time Regulations brought about a situation that deprived the claimant of his rights under the Working Time Directive, and on the facts of this case, the Working Time regime is therefore incompatible with the Working Time Directive. Well, we say that's the natural conclusion from paragraph 47. And further, employment judge goes on, I can see that the second paragraph of the decision of the Court of Justice could be interpreted as meaning that Mr. Stevenson is correct, and the consequences of the denial of one aspect of the right, namely pay, does in fact mean the right to leave has not been exercised. We say that's the necessary conclusion from paragraphs 36 to 40 of King. And then over the page at paragraph 31, the fact remains, 10 lines from the bottom, you've got then friend submissions on dissuasion, but then it goes on, the King judgment does not suggest that a worker who takes leave but is not paid for it is being deprived of a fundamental European right under the Working Time Directive, the Charter of Fundamental Rights or otherwise, because that specific issue was not before the court. Yes, it was. Yes, he was. In this case, the claimant was not deprived of a remedy in the same way as Mr. King. Correct. Mr. King had an impossibility, but he is given an effect. But the Court of Justice has already told us that paragraph 47, that what Mr. Smith has to do is precluded by Article 7 and Article 47. Which brings me then to carryover. And we say either it's a single right that hasn't been exercised, alternatively, effectiveness requires carryover in the circumstances of the law of Great Britain. Now, the question at paragraph 48 of King, back to King at page 741. The way in which King analysed this was precisely the same way.
Sorry, which paragraph?
Paragraph 48, starting 48 at page 741. Paragraph 48. And the question is whether there can be carryover, where appropriate, accumulating until termination of the worker's employment. And the way that the Court of Justice analysed whether there could be carryover, which was in exactly the same way as my Lady Justice Simler analysed the case in the Employment Appeals Tribunal. There were two different conclusions, but the actual what I rely on from my Lady Justice Simler's EAT case is that she was applying what we call the opportunity principle in King, and she arrived at a different conclusion, but she was applying the opportunity principle that arose from Stringer. So these courts are often asked, and do, domestic courts, to apply principles of EU law. And the opportunity principle in Stringer is effectively, if you're given an opportunity to exercise, then you can lose the right. If you're not given the opportunity to exercise the right to paid annual leave, then you can't lose that right and it carries over until termination. And in essence, can I just show you quickly, please, that in Stringer, and take you therefore to divider 26. Divider 26, page 411. Divider 26, page 411, paragraph 43. And King reads across, just as the EAT did, the opportunity principle into Mr. King's situation. So the question is, has the worker actually had the opportunity to exercise the right conferred on him? And we see that, and you'll see that that's also, Malone Friend took you to paragraph 43 of Kreuziger. That very same opportunity principle is referred to, but of course they use the normal name, which is Schultzhoff rather than Stringer. So at paragraph 43 of Kreuziger, they use the opportunity principle. And indeed, that's what the Court of Justice was doing in King. Now, they were applying to the opportunity principle the test of beyond control, because that was the test. And that was where my Lady Justice Simler and the Court of Justice differed. And one can understand why one differed. Was it beyond his control? And I've accepted that it was possible in this case, and effectiveness I don't think was argued in the same way. But in any event, beyond control is no longer the test. The test is the Kreuziger test. So unless Pimlico Plumbers can, which of course they cannot, show that they informed Mr. Smith. Mr. Smith, you have the right to paid annual leave. Unless they encouraged him. So it's, firstly, it's encouraged. Mr. Smith, please take paid annual leave. Secondly, inform. Mr. Smith, you have the right to paid annual leave. And thirdly, Mr. Smith, if you don't take paid annual leave, you'll lose it. Unless they did those three things, what might be called the reasonably practicable exercise of the health and safety right, they can't satisfy the opportunity test. And they can't in this case. They've never been able to show that Mr. Smith, that they did the opposite. And they not only did the opposite to Mr. Smith, they did the opposite to these courts. And they tried to avoid that quintessentially they can't meet the Kreuziger test. So then one looks at the duration of carryover. And if one goes to, again, King, please. And in King, the sickness cases, it noted at paragraph 55, EU law did not require carryover beyond 15 months for sickness cases. And why didn't it require carryover beyond 15 months? Because leave would stop reflecting the purpose for which it was there after 15 months. And also the difficulties. And what the case in what the Court of Justice said in King is at paragraph 56, whether circumstances such as those in issue in a case such as Mr. King, who's refused to remunerate, whether that's different from the sickness cases. Should a different rule as to the length of carryover? And there, one sees between paragraph 59 and 64 a coruscating judgment of the Court of Justice. They start slowly at 59. In circumstances such as those at issue, protection of the employer's interest does not seem strictly necessary, and accordingly does not seem to justify derogation from a worker's entitlement to paid annual leave. And that was where Sash Windows denied Mr. King, just as Pimlico Plumbers did, his entitlement to a worker and to his entitlement to leave. And then in 60, they drew a difference between Mr. King and that of a sick worker, in a situation in which the employer is faced with periods of absence which, as with long-term sickness absence, would have led to difficulties in the organisation of work, some protection of the employer might be necessary. But in fact, and here the Court of Justice gets going, on the contrary, the employer was able to benefit was able to benefit until Mr. King retired from the fact he did not interrupt his professional activity in its service. Here, Pimlico Plumbers not only benefited from non-interruption, they pocketed the entitlement that should have been Mr. Smith's. And then 61, well, complex area worker status, and therefore, Sash Windows didn't know it, neither did Pimlico Plumbers. It's irrelevant. It's for the employer, it's for Pimlico Plumbers to seek all information regarding his obligations. Against that background, as is clear from paragraph 34, again, going back to paragraph 34, which is the single right, and, I'm muddling again. Paragraph 34 is where you can't set out a precondition to the exercise of leave. The very existence of the right to paid annual leave cannot be the subject of any preconditions whatsoever, the right being conferred directly on the worker by the Working Time Directive. It's irrelevant whether you ask. And at paragraph 63, unlike sickness, an employer who does not allow a worker to exercise his right to paid annual leave must bear the consequences. Because if that's not the case, with gig working, with denial of worker status, with 1 in 20 workers not being afforded working pay, then if one reads down at paragraph 64, after Needle, the European Union system for the organisation of working time put in place by the Working Time Directive may not be interpreted restrictively. Indeed, if it were to be accepted in that context that the worker's acquired entitlement to paid annual leave could be extinguished, that would amount to validating conduct by which an employer was unjustly enriched to the detriment of the very purpose of that directive, which is that there should be regard for workers' health. So the court is analysing this as unjust enrichment.
So has the 2-year limitation been challenged in the 2014 regulations?
No, my lady. Well, I think it has been. It may be.
Has anyone else got any more up-to-date news than me?
Oh, at least this isn't being live streamed, my lady. I'm great. Yeah. So, anyway, so there you have it. You have a single right not exercised. You have all the other factors, and you come to the conclusion at 65. There's only two matters as to whether or not an entitlement then sounds under Article 7.2. And that's, has the employment terminated, and has the employee had the opportunity to exercise the leave? Mr. Smith hasn't. His employment has been terminated. And therefore, under paragraph 65, Article 7 of Directive 2003 must be interpreted as precluding national provisions or practices that prevent a worker from carrying over and, where appropriate, accumulating until termination of his employment and employment relationship paid annual leave rights not exercised in respect of several consecutive reference periods because his employer refused to remunerate that leave. And you add that in the operative part under paragraph 66, 1 and 2, and we say that should compel this court to carry over Mr. Smith's rights. I should also say that in nearly every case, by overruling Bear Scotland and applying the old series of deductions tests, the Agnew test, that might answer effectiveness. In nearly every case. The case which it wouldn't answer effectiveness is where in the final year of one's employment, an employer might have started paying annual leave and the full amount of annual leave is taken so that there's no Regulation 14 claim. But we say, there are two ways, and that's why, and I'm sorry if we confuse the court by splitting up, there are two ways in which to find for Mr. Smith. One is via the first route shown by my learned friend Mr. Ford, and the other is by the route that I've addressed. Unless there's anything further, my ladies, we say all of these should carry over and accrue until termination of the employment. My own friend, sorry, there's a Reg 14 amendment which we've handed up. And I should just take, I'm grateful to my own friend, forgive my own friend for taking time. Yes. And what one has here is it builds on the words in Plum and Duncan. And you'll see at 14 and 15, those are Plum and Duncan amendments. That's because of sickness, and I hope I've explained why it's limited as it is. 18 months, in fact, is the period chosen by domestic law. And then you have my learned friend, Mr. Ford's case, which is set out at Regulation 16, and that's on all, that's fully within King. And then you have 17, which is, and I beg your pardon, and Kreuziger. And then you have my 17, which I say is also within King. And then you can see that those flow into Regulation 14 as the court concedes. And that's, as my own friend Mr. Ford said, those can be done on ordinary leasing principles, but of course this right is also under Shimizu horizontally directly enforceable.
Thank you very much. Yes, Mr. James, over to you.
Sounds complicated, doesn't it? We say the complexity in this case arises from the fact that my learned friends are arguing it back to front. They are trying to persuade you that Mr. Smith had a range of good claims, and because he had a range of good claims, he must have brought them, or be deemed to have brought them, and must have brought them in time, or be deemed to have brought them in time. We say the logical order in which to approach the issues here is as follows. Number one, what claim did he bring? Number two, what were the time limits applicable to that claim? the domestic time limits. Number 3, was the Employment Tribunal entitled to conclude that his claim was outside the time limit for the claim he brought? And fourthly, the embellishment which has been brought to this court is the ordinary Employment Tribunal time limit in breach of the principle of effectiveness. And we say the answers to those questions are simple. The claim he brought was a claim for leave taken. It didn't raise the issues in King. The issues in King arise where an individual doesn't take leave because he knows it's going to be unpaid. Those issues don't arise if the individual takes his leave. Where the individual takes his leave, he can, as even my learned friends accept, take the simple course of bringing a claim within 3 months in the Employment Tribunal. That Mr. Smith failed to do. There's no doubt, it's not an issue in this court, that his claim was outside the domestic time limit, and indeed there's no challenge to the tribunal's conclusion that it was reasonably practicable for him to bring a claim within that time limit. And we say it's astonishing for my learned friends to be submitting, as we now understand them to do, British time limit. Use English, perhaps I should say British, time limit of 3 months for a tribunal claim is something which it is excessively difficult for a worker to comply with. Certainly the implications, if they're right about that point, are extraordinary. Just sketching in where I'm going before I develop the individual ground. In our submission, it's important to see this in overview. King was directed to a problem, a lacuna in the law. The EAT's decision, however understandable in the King case, meant that an individual had either to take his leave and bring a claim for lack of pay in respect of the leave he had taken, or not use it and lose it. And the solution found by the European Court was that if he didn't use it, he didn't lose it. There's no such difficulty for somebody in the position of Mr. Smith. If, despite the fact that he's not going to be paid, he takes the leave, he can bring the ordinary claim that employees bring up and down the country every day within 3 months for non-payment of holiday. There's nothing difficult about that, and the tribunal found in this case there was nothing difficult about it. He could have done it. It was reasonably practicable, and there's no appeal against that finding. And it's simply wrong to begin the argument in this case with the assumption that this was a claim for something for which it was not. This was not a claim for untaken leave. This was a claim for taken leave. And I want to deal with that question first. The claim that was brought, it was a claim for leave taken. And it's important to start, and it might be said also to finish, with the pleading. The pleading is the key document, the ET1. Pleading is rather a posh lawyer's word, but it's a statement of case. And Mr. Justice Langstaff, in a famous judgment with which members will be familiar in the Chantok and Turkey case, made an important statement about it. That's at tab 36. And I want to start reading at page 662 in the file numbering. It's page 531 internally, in the judgment of Mr. Justice Langstaff.
Which paragraph?
15. In para 4 of his judgment, the judge identified the claimant's case, saying that she was one of the Vivesi people, not from what was asserted in the claim, lengthy though it was, but from material that could only have come from either her witness statement, which was brief, or what he was told. I should say, by way of background, this is a question of whether you could bring a caste discrimination claim as part of a wider race discrimination claim. And as Justice Langstaff says this: I do not think that the case should have been presented to him in this way, or that it should have formed part of his determination. That is because such an approach too easily forgets why there is a formal claim which must be set out in an ET1. The claim as set out in the ET1 is not just something to set the ball rolling, an initial document necessary to comply with time limits, but which is otherwise free to be augmented by whatever the parties choose to add or subtract, on merely their say-so. Instead, it serves not only as a useful, but a necessary function. It sets out the essential case. It is to that which a respondent is required to respond. A respondent is not required to answer a witness statement nor a document, but the claims made, meaning, under the Employment Tribunal's Rules of Procedure 2013 regulations, the claim as set out in the ET1. I readily accept that tribunals should provide straightforward, accessible, and readily understandable fora in which disputes can be resolved speedily, effectively, and with a minimum of complication. They were not at the outset designed to be populated by lawyers. Come back to that. And the fact that the law now features so prominently before employment tribunals does not mean that those origins should be dismissed as of little value. Care must be taken to avoid such undue formalism as prevents the tribunal getting to grips with those issues which really divide the parties. However, all that said, the starting point is that the parties must set out the essence of their respective cases on paper in respectively the ET1 and the answer to it. If that were not so, then there would be no obvious principle by which reference to any further document, witness statement or the like, could be restricted. Such restriction is needed to keep litigation within sensible bounds and to ensure that a degree of informality does not become unbridled licence. The ET1 and ET3 have an important function in ensuring that a claim is brought and responded to within stringent time limits. If a claim or case is to be understood as being far wider than that set out in the ET1 or ET3, it would be open to a litigant after the expiry of any relevant time limit to assert that the case now put had all along been made because it was their case, and in order to argue that the time limit had no application to that case, could point to other documents or statements not contained within the claim form. Such an approach defeats the purpose of permitting or denying amendments. It allows issues to be based on shifting sands. It ultimately denies that which clear-headed justice most needs, which is focus. it is the enemy of identifying and in the light of identification resolving the central issues in dispute. I read that in full because in my respectful submission, my learned friends have infringed that principle in their argument in this case. If we go to the pleading in the core bundle at page 177. Grounds of claim start at 176. And the Employment Tribunal, as we'll see, had to grapple with the question, and so did the EAT, what was the claim that was being made on this form? Not in witness statements or submissions, but what was the claim that was being made on this form? And you see grounds of claim. We come to paragraph 5 on page 177, and this is the headline claim in relation to holidays. This is the assertion of what the employer has done wrong, which then is subject to further observations as regards remedy. Paragraph 5. R1 deducted 20% from my earnings to pay tax. I was provided with a payslip. I took annual leave, but R1 did not pay holidays under WTR. And that, we say, is the clearest possible statement. I took holidays, but I didn't get paid. Not saying I've got a lot of holiday outstanding, or I wasn't able to take holidays because they weren't being paid for. I took the leave, but the respondent didn't pay holidays. Paragraph 21 says on page 182, as a worker I was denied paid holidays from the outset or at a later stage in my contract. That has to take its quality from what's already been asserted. He's not saying he didn't get the holidays, he's saying he didn't get the pay. Otherwise the statements would not be reconcilable. And then under paragraph 37, unlawful deduction from wages. Well, clearly he's saying that that's a matter of pay, not denial of holiday. So far, all consistent with the fact that he is claiming pay and not the denial of holiday. And then at paragraph 43, I seek compensation for unfair dismissal, wrongful dismissal, dismissal on grounds of disability, detriment on grounds of disability, unpaid wages. These claims failed, by the way, on their merits. Unpaid holiday, again. And he's seeking compensation. So it's financial remedy that he is seeking in relation to... Yeah. Well, he wasn't an employee, so he couldn't have unfair dismissal or wrongful dismissal. He was only a worker. So throughout the claim form, what is being asserted is that there's been a failure to pay for holidays taken. And that's how the tribunal understood it, with all its experience, E.J. Morton's experience, and that's how Mr. Justice Choudhury, the President of the Employment Appeals Tribunal, understood it. If we go just to see, there had been some toing and froing before the hearing when the respondent had sought some clarification as to precisely what claims were being brought. And if we go to the supplementary bundle, tab 3, page 224, is a commentary on some exchanges which had taken place previously. The first was a document at page 213, which the claimant described as a list of issues, but it was a statement from the claimant's side as to what was an issue. And there's a reference you see there under holiday pay to 1.2 on page 214 to refusal of rights under 13.1. And the respondent responded, indicating that as far as they were concerned, there was no claim to pay.
Sorry, where are we looking now?
This is in tab 2, page begins at 218, but the relevant bit is at page 220. And the response to that comes at 224.
Hold on, where are you relying on in 220?
Well, it's paragraph 8.
Do you want us to read it?
Yes, I'm so sorry.
So paragraph 8 does divide in response to in two ways. Yeah. 8.1 with regard to any claim in respect of an annual leave that was taken, and 8.2 with regard to any claim may sue in respect of annual leave not taken.
It's asking the question.
It's not asking a question. It's providing a response. It's saying, insofar as you're making that claim, the burden is on you to show X. And you would not be entitled to include Y.
And
well, it's saying
what comes back? I'm sorry.
Well, I think it's saying if and insofar as such a claim is being made, contrary to the 4th of October document.
Exactly.
So what it's saying is the 4th of October document appears to suggest something different, but if contrary to appearances, it's suggesting 1 and 2, then that's our answer.
Yes. Adopt that succinct summary, if I may.
But how does that help you?
Yes, yes. We get the response then at page 224, the claimant side, saying the purpose of providing the particulars of holiday claim is to give an overview of the claim, not to be read as a skeleton argument or complete authoritative document of law. For the avoidance of doubt, these particulars don't replace, amend or otherwise change what's pleaded in the grounds of claim. So he's saying we stand on our grounds of claim. Specifically, it does not change or replace the claimants entitled to paid annual leave under regulations 13 and 16. So specifically, it's saying 13 and 16, not 14. There's no claim for in lieu, and no suggestion that there's some kind of king in lieu claim being put forward. It's specifically regulations 13 and 16. So that not only did the Employment Tribunal have before it a pleading which did not extend to any form of in lieu claim or any claim for untaken holiday leave, it had an express clarification that the claim was to be read in accordance with its terms, was a regulation 13 and 16 claim, and therefore not, by plain implication, a claim for untaken leave or an in lieu claim, either under regulation 14 or under King. And that's how the tribunal saw it at page 156 of the core bundle. paragraph 40 that you've already read. There was an argument as to whether a Regulation 14 claim had been brought, and the judge is recording here at paragraph 40 her conclusion and reasoning about that. We say it's absolutely plain from the ET1, which is the key document, that no Regulation 14 claim had been brought, no claim for untaken leave. But if there had been any doubt about it, it was resolved by the express statement made on behalf of the claimant. And Mr. Justice Choudhury reached the same conclusion in the EAT. If you go to page 103 of the core bundle, paragraphs 94 onwards. I know you will already have read those. You might wish just to refresh your memory about them, and I want to emphasise what's said in paragraph 96. Beginning of paragraph 96, it contains a typographical error. It's not now here, it's nowhere. Nowhere in the grounds of claim does one find express reference to a claim for Hillel on termination, which is what the claimant sought before the tribunal. At most, the grounds of claim can be said to include a claim for paid annual leave for each year of employment. However, even when that claim is made, it unhelpfully appears under a heading of the claim for unlawful deductions from wages. Williams correctly points out that the conclusion of the House of Lords in Stringer was that the definition of wages in section 27 includes payments for annual leave, and the tribunal, as I'll show you, was conscious of that and of what had been decided in Stringer. And she submits that, as such, the heading does not preclude the claim as one brought under the WTR. I agree that the heading does not preclude such a claim, but one can expect at the very least a correct statement as to the substance of the claim being made. The paragraph does not refer to a payment in lieu on termination in respect of any accrued entitlement. In the context of holiday pay, where there are several distinct and separate rights that may be established and which may give rise to different remedies, it's incumbent on the claimant to be specific. That should not be read as an injunction to stipulate specific statutory provisions in every case. In the relatively informal setting that is the Employment Tribunal, it's the substance of the pleaded case that matters. However, that relative informality cannot be relied upon to advance claims that are not, as a matter of substance, alleged.
I think we need to read on to paragraph 97 just for completeness, for the whole context.
Can I let you read, in fact, to 101? I respectfully submit that it's important to respect, first of all, the judgment of an employment judge as to what is properly raised in a claim, and secondly, the judgment of the President of the Employment Appeals Tribunal as to what can properly be expected in a claim. Those who have experience in employment tribunals, and I'm conscious that two members of the court have the highest imaginable experience of such tribunals, know of the bedevilment that is caused by ambiguity in ET1s, and particularly where a claimant is represented. A tribunal is entitled to expect that a distinct claim for untaken leave, for payment in lieu of untaken leave, should be set out in the claim if it is to be asserted. Of course, it doesn't stop there, because there was a history to this. The sash windows case was decided by the Court of Justice on the 29th of November 2017. A year later, on the 26th of November 2018, the claimants applied to amend their form if they felt that there was some new route open to them as a result of sash windows. The obvious thing to say was, well, in the light of the Court of Justice's judgment, we'd like to amend our claim. In fact, they applied for a wholly different set of amendments. I needn't take you to them, but just for your note, it's at page 203 of the core bundle. It's a series of amendments they sought to their disability claim, but sought no amendment whatever to the claim we're now considering, the holiday pay claim. The set of amendments are quite complex, but I don't think there's going to be any dispute that they all related to disability and they did not relate to holiday. 6 months after that, you have the hearing before Judge Morton, and there is then a further opportunity for the claimant to amend their claim to include a claim for untaken holiday, a sash windows claim, a Regulation 14 claim. They don't take it.
Sorry, my bundle finishes at 2:02. If it's thought I need to read the judgment of Judge Martin.
That's a sadness. Is
meant I didn't have to
that
read
a
it
common
yesterday.
fault, may I ask, for the other members of the court?
No, I've got
You need that.
I've got the judgment for the preliminary hearing.
Yes, so have I.
So my bundle ends at page 212.
Well, perhaps I don't need this immediately, but perhaps if someone could.
Yeah, we'll make sure that's remedied overnight. But I think I'm being
Don't need the whole
uncontroversial in this, in saying I'm being uncontroversial. That's an unmarked one.
Well, in fact, don't give me the whole bundle because, of course, I've got marked up mine.
Yeah.
So if someone could just arrange to send through to my clerk the actual few pages I'm missing. But thank you for the offer from your instructing solicitors. Yes, I'm sorry to have interrupted. You go on.
Having, as it were, passed up one opportunity to seek an amendment, then the hearing before Judge Morton on the 18th and 19th of March 2019 provided another, and she noted the fact that there was no application to amend. If you go again to page 156 of the core bundle, back to paragraph 40, some 7 lines down in paragraph 40. More importantly, in my view, was the claim that was originally pleaded, no application to amend having been made. She noted the fact that there was no application on that occasion. Now, one does have to ask the question, why not? We've all been there. That moment when your opponent's saying, nowhere in the pleading is it asserted. A feeling of cold steel through the heart. And one searches one's pleading, argues whatever one can about what's there, and then one says, but if I haven't pleaded it, please may I amend, and one furnishes a suitable amendment. It is beyond understanding why that was not attempted at this occasion. Clearly there was a controversy. Putting it at its lowest, Mr. Stevenson could hardly assume, on the basis of the unhappy pleading as it's described, that he had raised any claim for an in lieu payment or for untaken leave. Why not amend then, or at least apply to do so? And it's an extraordinary thing, we say, to make no application at the time, and then to run appeals up to the Court of Appeal on the basis of what would have to be, I think my learned friends would have to accept, with a highly unfortunate and defective pleading, and say that the tribunal was compelled to take a lenient view of it, even though it was drafted by counsel and even though there had been repeated opportunities and 18 months since sash windows in which to make that amendment. And there's a very serious implication, we submit, for tribunal practice if parties are to be allowed to say on the basis of such a pleading, well, if you hold it up to the light and imagine the insertion of a few words here and there, it would almost do the job, and therefore it must be taken to include the relevant claims because the relevant claims are so important and because I would have won on them. The first step is to identify your claim, and we say that the tribunal was right, or at the very least justified, and that Mr. Justice Choudhury was right, or at the very least justified, in concluding that it did not raise the claims which my learned friends now assert. It simply asserted a claim for unpaid holiday. Now, it may have been a tactical manoeuvre not to apply to amend. It may have been done on instructions. But as Mr. Justice Choudhury points out at paragraph 108, just for your note on page 109 of the core bundle, you're stuck with the case you run. Not presenting the case in the way you wished you had presented it is not a ground of appeal. So it's very important, we say, that one starts with the fact that this was simply a claim for holiday pay taken, unpaid. It was a claim for payment, not a claim for an in lieu entitlement, a holiday not taken. And once one starts with that clearly in mind, we submit all else falls into place. Mr. Smith was content not to cross-examine because it was his position, borne out by the tribunal's judgment and by the Employment Appeals Tribunal's judgment, that the claim did not raise a claim for untaken leave. And that being the case, it's just irrelevant to see whether there was or there was not a good claim to be made on the facts for untaken leave. If the claim wasn't there, nothing mattered. And that may be one explanation for the general way in which the facts are approached, that the facts did not need to be found in detail on the conclusions which the tribunal reached. Because the tribunal reached the conclusion that there wasn't a claim for untaken leave. The claim for taken leave was out of time. It ruled it would have been reasonably practicable to have brought the claim in time. End of. What has happened here, and I think I speak with some confidence, is that a claim which was initially genuinely seen as a claim for leave that had been taken but not paid, that's to say, a claim for payment, has been seen to have a wrinkle because of the table in the witness statement. And I'm going to come to that in a moment. But at the time the case was presented to the tribunal, really both parties were not identifying, neither party was identifying a possible factual scenario in which there was still leave untaken. The claimant's solicitors had provided some particulars about when Mr. Smith took his holiday, done informally by email. You have, I hope, the relevant documents in the supplementary bundle at pages 357 and 356. I read them in that order because it's an email, and in the unhelpful way of emails, you have to start at the later page and read back. This is Mr. Parsons of my instructing solicitors writing to the claimant solicitors. It's the second paragraph. We note that your client says he took 2 weeks of holiday, each summer holiday. To clarify, is that the only holiday your client says he took? This is in early November 2018. The answer comes back at page 356. 2 weeks in the summer, dates varied each year. Time off at Christmas, length and date varied each year. Bank holidays. He says he may have worked the odd bank holiday, but cannot now recall. Now, if you add simply the 2 weeks in the summer to the 8 bank holidays, or you might say 7 or 6 if he might have worked the odd one, you're already almost at your full 20 days entitlement. And the time off at Christmas, as we'll see, could well have typically exceeded that, because when you go to the witness statement, you find, turning to supplementary bundle, page
231 is the start.
231.
Table's at 240.
Yeah, it starts at 231. Paragraph 18. Took holiday leave, but I never received holiday pay. Again, entirely in line with his pleaded case that this is a complaint about not being paid holiday pay. I took time off each year in the school summer holidays to go on a vacation with my family, usually around July, August. That presumably is the two weeks that his solicitors had particularised. I took time off at Christmas. I didn't get paid for that leave, and always notified the control room any leave taken. Then sometimes I worked bank holidays and did not get paid leave. And then he goes on to deal with this Christmas holiday at paragraph 29 of his statement. Now, it's right to say that he's dealing here with the 2010-2011 holiday, but it's interesting to see how he puts it. He says, these documents, referring to payslips, show no pay after 18th December 2010 to 5th February 2011. This supports what I say I would have taken time off over the Christmas period, and then absence from the 5th of January was due to the heart attack. And he had a heart attack on the 5th of January, so it's sick leave thereafter. But he's saying that the 19th of December to the 4th of January, which I make 14 days plus 3 weekend days, would all have been holiday. And what he's saying is, well, not that this was in some way exceptional. He's saying this supports what I say about taking time off around Christmas. So that if that was in any way typical, adding those 14 days to the 10 days he has in the summer and the 6 or 7 bank holidays, he's already at 6 weeks.
So are you asking us to find facts?
Absolutely not.
Well, it feels a bit like that.
It was absolutely not. And what I say is it's my learned friends who are inviting you to find facts.
Well, I don't think they are. I think what they were saying is that there was a set of facts that were accepted to be a factual basis I know you don't agree with that, but I'm just clarifying what I believe the case that's being put by the appellant, which was brought about in part by the decision, for whatever reason, I've now heard your reason, for choosing not to cross-examine.
Well, to make our position clear, we are absolutely not saying that the Court of Appeal should become involved in asserting fact, in dealing with facts. But what the learned friends are not entitled to do is to look at a decision which was concerned with a jurisdictional reason, whether a claim was made in time, and piece together retrospectively a claim which they say could have been made, which was good. And what I'm showing you is that, in fact, what the solicitors, claimant solicitors, had said in their particulars was probably right. What the claimant said in general terms in his statement was probably right, and that it's actually very unlikely that there was any untaken leave. And learned friends really began their submissions by saying, look, there's an obvious claim for untaken leave here. They've derived that from looking at the table at paragraph 40. But as Mr. Ford himself fairly conceded, the table was not self-evident to him when he first looked at it. It's very confusing, not least by failing to treat the leave year in the correct way. And in fairness to the claimant, all he says about it is, look, this is what appears from my pay slips, or what appears to be missing from my pay slips, and he's not making a categorical assertion about it. But what has happened here is that at the Employment Appeal Tribunal, the claimant side noticed this point that there was possibly a discrepancy, if you base yourself on that table, between the total leave to which he was entitled and the leave he'd in fact taken. And they started to mount an argument that the tribunal ought to have made a finding on uncontroverted fact. And there was no ground of appeal, strikingly, to the Employment Appeal Tribunal based on this. There was no suggestion in the grounds of appeal to the Employment Appeal Tribunal that the Employment Tribunal had made a finding without evidence or contrary to agreed evidence in finding that the leave had been taken. The claimant side had not been slow in raising arguments about the facts. They had applied to the Employment Tribunal and made an application for reconsideration of the tribunal's judgment on other procedural, on other factual issues. In particular, they had applied for reconsideration in relation to the question of whether the claimant had been on leave at the end of April and the beginning of May. And that application was unsuccessful, and when it was unsuccessful, in the reconsideration judgment, which you have at page 332, they then appealed to the EAT on that question and said it was a perverse finding that had been made about the April-May date. There was no challenge at all to the tribunal's conclusion that he had taken all his leave. So the attempt in this court now to say that, well, the starting point for all this is that there was clearly a claim for untaken leave. The tribunal foolishly failed to realise that that was common ground, and that this court should conclude that it had thereby erred in law is a travesty of the history. The tribunal was simply ruling in the first instance of what the claim was. It noted that the witness statement seemed to be in line with the claim, which was right. The claimant's own particulars were equally in line with the claim. Nobody on the claimant's side suggested otherwise until leading counsel, puzzling over that rather difficult table, began to say, well, mustn't it have been implicit that there was an untaken leave claim here? Now, that's not something that you're entitled to raise on appeal, let alone in this court. And what it means, if I'm right so far, is that the whole case has to be approached on the basis that there was one claim before the tribunal, claim for non-payment for leave that had been taken, and that one claim was outside the ordinary English time limit. And whilst I shall have quite a lot to say about it tomorrow, in our submission the case does become a lot simpler once you see what its true outlines were. We will be submitting, as we say is clear when you look at the judgment in King, that King is only concerned with leave that is untaken, because that is the only circumstance in which the individual doesn't have a remedy. Going back to what I hope not unkindly or unfairly said about the EAT's judgment in King, it did leave this problem that somebody who was deterred from taking leave by the fact that it was not going to be paid didn't appear to have a remedy. European Court says, yes, they do. They can claim it all as an in lieu payment. But there was no suggestion in King that an individual would not have an adequate remedy if they had taken the leave, because taking the leave generates all the rights in English law to bring a perfectly standard tribunal claim within a standard time limit. And that is what Mr. Smith failed to do. Of course, I will have to address at the end the extraordinary suggestion that the ordinary time limit in English law for working time and, it would seem, unlawful deduction claims is such an affront to justice that it must be regarded as ineffective. It's not a submission I recognise from the Employment Appeals Tribunal, but we'll come tomorrow prepared to meet it. Now, I'm sorry if I've taken that slightly slowly from the outset, but in our submission it's absolutely crucial to appreciate what this claim was, that the ET and the EAT were entitled to conclude that it was what it was, which was a claim for taken leave, a claim for pay, for leave that had been taken, and that certainly a range of the points that my learned friends advance simply don't arise on that footing. And the thrust of the case has really been to say, well, there was a good claim here, it ought to have been pursued, and if it had been pursued, they would have won. No, it was a very what the tribunal was left with was a very simple claim, and it was out of time on the ordinary English time. Now, I will address the other questions tomorrow, but I don't know if that's a convenient moment to break.
No, I think that sets your stall out very nicely. Thank you very much indeed. Very well. 10:30, please.
Sounds like the world is leaking through the roof.
I'm sorry. Yeah, well, I think I'll run